Good evening. Thanks for joining us. I'm Richard Gearhart. You're watching a very special edition of KSBY News on Facebook Live. For the next 30 minutes or so, we will be taking an in-depth look at what's happening in the Kristin Smart murder trial. We're calling this Beyond the Headlines because we want to take you beyond the daily reporting and dig deeper into some of the issues surrounding this trial. It's a complex case, more than 26 years in the making, and there's a lot to talk about. So first, let's get you up to speed on what happened this week in court. It was a short week. Court was in session for just one day. That was on Monday. The prosecution called Kristin Smart's sister, Lindsay Smart Stewart, to the stand, along with several witnesses who were among the last people to see Kristin before her disappearance from Cal Poly in 1996. On Tuesday, both sides returned to the courtroom expecting to resume testimony, but the judge announced the trial would be put on hold until next Monday. A member of one of the juries apparently had an unexpected emergency, and the judge said that she did not want to run through the case's list of alternates. We'd also like to invite you to share your comments and questions in the chat below. If we don't address your question tonight, we will be compiling them for future episodes. And my guest tonight is San Luis Obispo defense attorney Ilan Funke-Bilu. And you know what, we're going to start right off the bat with that idea of kind of postponing this trial. So on Monday, I was in court. On Tuesday, it was set to resume. And then there was this delay because the jury had an emergency. And one of the things that keeps popping up, or that we keep asking people about, is the fact that, you know, we've got this limited list of alternate juries and this trial, or jurors rather, and this trial is expected to be pretty long. When do they start? How do they make that decision about whether to delay the case or to actually put an alternate juror in?
Well, I understand there's at least a half a dozen alternates on each jury, and it depends on the length of the jury, the time of the year, and the complexity of the case. So this is a very lengthy trial, at least it's an expected trial. So you would expect a higher number of alternates. I've had trials that lawyers will give a 1 week estimate and we would have maybe one or no alternates. So it's a function of those factors.
All right, perfect. And then when I was sitting in court on Monday, it was the last, I missed the other family members. So the other, Stan and Denise obviously testified. Kristin's brother, Matt, testified. I didn't see that, but on Monday when I was in court, Lindsay, her sister, testified. And they asked a lot of questions about, from both the prosecution and from the defense, about sort of how close the family was, how close-knit the family was. But she was really on the stand for a fairly short amount of time, I'd guess less than 20 minutes. What is the point of putting those family members on the stand? Obviously, she can't comment on, you know, what happened at Cal Poly that day or anything about Paul himself.
Well, I think what the prosecution is trying to do is trying to humanize Kristin Smart and trying to portray a young lady, a young victim who was loved and was part of a strong, loving family. How much relevance this really guilty or not, that's up to the jury. But I think that's what the, it's to me, I would consider this foundational evidence to show the jury that she was loved and she was a real human being, and her loss means something to a lot of people, but certainly her family.
So one of the things that we have gotten a lot of response on in some of our coverage is when the defense has actually talked about Kristin Smart and brought into question, if you will, her character to an extent, talked about her kind of engaging in some behaviors that were a little bit risky and having a history of kind of going off unexpectedly. And there is, at least amongst our viewers, and I would assume then obviously potentially amongst the jurors, this sort of like feeling that they shouldn't be going down that path.
Victim shaming is a delicate area, and both attorneys have been around for many years, and I'm not going to second guess their tactics. They're aware of the problems of victim shaming, and I suspect the reason why they're introducing that is to show that she could have easily have done what she's always done in the past, which is disappear without notifying her parents or friends or so forth. And it's not so much victim shaming as enhancing the defense, which is going to be that she disappeared, but through no fault of Mr. Flores, but through her own lifestyle. So again, it's perspective from the prosecution, victim shaming, from the defense. We're trying to show that more reasonable interpretations that she disappeared like she's done several times before. And you can't blame Mr. Flores for that.
And then the other witnesses that were on the stand on Monday were all these fellow students who were at that party, the sort of infamous last party where she was last seen, and then walked back to the dorms with several other students and Paul Flores. And one of those students actually testified. Another couple of students, one of her neighbors in the neighboring dorm room testified. And there were some inconsistencies that kept cropping up, right? So the testimony that we heard is the same testimony that we've heard before, obviously what was on the podcast, et cetera. But the defense attorneys were really bringing up and kind of catching, maybe, if you will, the witnesses in the statements that they made back in 1996 and then in 99 and subsequently through the years has changed a bit. When we see inconsistencies like that, how much does that matter? How much does that play for the jury?
Well, you know, Richard, that every single jury that I've been involved with, and every single, I can't think of any jury trial where a jury does not receive an instruction on witness credibility. And I've just taken a small portion of what's called Cal Crim 226, and I'd just like to read it. It's just a short paragraph, and I think it'll answer your question. And the jury is instructed as follows, at least in part: do not automatically reject testimony because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes forget things or make mistakes about what they remember. Also, two people may witness the same event yet see or hear it differently. So that's inconsistencies in and of itself may be important if the jury so concludes after considering all the facts and the instructions, part of which I've just read to you, the actual instruction that the jury will get. I can promise you that. And lawyers don't usually promise things, but this I can promise you. So again, if the inconsistencies are material, then that may go to the credibility of the witness, and the jury certainly has the power to disregard the rest of his or her testimony if the jury feels the inconsistencies are truly inconsistencies and not forgetfulness. And then the jury has to consider, is the inconsistency really material, or is it really significant? That's why we have jury trials. The jury determines the importance and the weight to be given to inconsistencies. Not the attorneys, not the judge, but the jury. They are the triers of the facts.
And you know, that's one of the things that sort of struck me too, listening to it. Well, a couple of things, right? We've talked a lot on this particular show, about some of the jury instructions, and I'm not sure that many of our viewers are kind of aware that they get those explicit directions. And so that sort of helps explain, you know, what we're seeing in some of the testimony, I think, as well. But some of it, I noticed that it sort of changed over time, and I think understandably so. So for instance, Cheryl Anderson, she had given a statement where she wasn't really questioning Paul's motives or pointing out Paul's motives as being super negative right after the event, but you know, he wasn't ever discussed as a potential suspect or even a person of interest at that time. You know, she had no reason to sort of suspect him. But then with more information coming out, you would obviously think that her opinion of him is going to change over time, and the jury must understand that, right? You know, so her viewing him as potentially being guilty is going to change with the more information she gets over time.
Well, I can assure you that the defense will drive that point home, absolutely. But again, that's why we have jury trials. That argument is a defense-oriented argument, and if the jury thinks that her opinion is biased because of information that she learned years after the fact, and therefore the jury should not put any weight on her testimony. The jury has that power, and thank God it does.
So bias is really, that's one of the things I really, really wanted to talk about today, because I think that's really important. I mean, I think we have bias everywhere, and some of the bias we probably don't even know that we have. But isn't bias sort of part of a trial, right? The defense really was kind of pushing this point with one of the witnesses, Margarita Campos, because she is apparently a member of a Facebook page about bringing justice for Kristin, and clearly has made statements in the past, according to the defense and according to some of the statements that they brought up, that she thinks personally that Paul's guilty. But obviously, the DA thinks Paul's guilty too, or he wouldn't be coming to trial, right? Is there something wrong with thinking that somebody's guilty as a witness?
Well, of course, bias is akin to inconsistencies. I've only read you a small portion of Cal Crim 226. There's another portion of Cal Crim 226, a specific instruction that the jury will get, that talks about bias. And the instruction instructs, and instructs is just a fancy word for the law that is the court provides to the jury. The instruction is that the jury must consider bias and determine what weight, if any, to put on a witness's testimony. Again, if the bias is so strong that the jury feels that the testimony is tainted and is not credible, then the jury has the power to reject it. But just because a witness is biased doesn't mean that the witness is untruthful. And so bias, like inconsistencies, can't be viewed from a single perspective. You got to look at all of the facts, and only a jury is qualified to give us what those facts ultimately mean, not the lawyers or the judges.
So one of the witnesses that we just showed a picture of, Ross Ketchum, he just attended the party. And he saw them together. And then his testimony had some inconsistencies as well. He talked about the fact that he thought that he saw Paul and Kristin together. He definitely saw them together drinking, but there was a bunch of discussion about whether or not he had his arm around her. And again, these were like inconsistencies being pointed out by the defense attorneys. And one of the things that came out in the questioning that, again, I didn't obviously catch me by surprise because I know this stuff happens, but it was interesting that it came out in the testimony, was that he had met with prosecutors ahead of time for what he called preparation for the trial. So, how does the jury sort of take that idea of preparation? What's actually allowable in terms of preparing a witness for testimony?
Well, I'll put preparation in quotes. The defense might characterize it as coaching. Mm-hmm. It's fair game for cross-examination. Anytime a prosecutor speaks with a witness, the entire content of that conversation has to be made available to the defense under the California discovery laws. So I know all the attorneys in this case, and they're all professional, and I doubt that Mr. Prevrel would coach any witness. I don't. Coaching is pejorative, and it's. I think it's unethical. I don't for a second think that Mr. Prevrel is unethical, and so. But again, one thing about my profession, it's rare. It's almost always true that that when you're dealing with testimony, you're dealing with a two-edged sword. So the prosecution will argue that, yes, Mr. Ketchum is an inexperienced witness, and we spoke with him, and we told him about testifying, and we told him about telling the truth. And of course, then when it comes to the defense turn, you were coached by the prosecution. Why did you feel the need to speak with them? And so again, that whole area of contact between a prosecutor and a witness is fair game. And again, the weight to be placed on that is to be determined by the jury.
And so, honestly, both those things that you just said were literally spoken in court, right? At one side, it came out that, they had spoken and the only expectation was that he would tell the truth. And then the others, obviously the defense side, really sort of insinuating that he was coached for his testimony. And that was like one of the reasons that this inconsistency popped up about whether or not he remembered Paul having his arm around Kristin. The other thing that kind of popped up that made me question a little bit what goes through juries' minds, and obviously you don't know what goes through juries' minds, but you've done this a lot and you've presented evidence in front of a lot of juries, and these are things that you think about, no doubt, right? Is that when he was talking about her falling at one point in time, he referred to her falling off an area of the kitchen and falling off a washing machine. And that kind of became a point in the courtroom because obviously washing machines aren't necessarily in kitchens. And I have a feeling, or my perspective was that he was just really, really nervous about testifying. And maybe it was a stove or something. How much do nerves play into it? And how good are juries at sort of overlooking those types of problems?
Well, again, a good jury is a jury that finds the truth. A bad jury is a jury that does not find truth. Or cannot find the truth. So everyone is nervous when they come into the courtroom. Even with all the experience that I've had, there are times, even today, where I can be nervous in a courtroom. You're dealing with people's lives, you're making important decisions, you're impacting people. So you would expect people to be nervous, and you would expect them to be even more nervous when they don't have 43 years of experience behind them. To give them some sort of comfort level when they go into a courtroom. So will a jury see that? Of course a jury will see that, because the jury themselves are nervous. Most of them probably have never had the task of deciding the guilt or innocence of one of their peers. So they understand, trust me, juries and jurors understand nerves, and they understand nervousness. Again, just because a witness is nervous doesn't mean they're untruthful. The reverse of that, of course, is that sometimes you have a defendant who you're reluctant to put on the stand because you're so concerned of his nerves that the jury might misconstrue his nerves and his nervousness as consciousness of guilt. So again, the jury's got all that power to determine whether nervousness is synonymous with guilt, or is it just synonymous with innocent nervousness because of inexperience with the whole criminal justice system in the courtroom?
How about kind of some rules for us, because we've had a number of questions, and obviously I don't know the answer to these questions because I'm not an attorney, and that's one of the problems with being a journalist, right? Is that you have to kind of be a jack of all trades and sort of like bone up on this one situation when you're covering it. But what are the rules about Susan Flores testifying? And there's been a lot of questions about that, right? Because she's been sitting in the courtroom at times. She was sitting in there for opening statements. Witnesses are usually precluded from sitting in the courtroom before they testify. Can she testify? And is there a limit to who she is expected to testify against? Like, can she actually be asked questions about her son? Can she be asked questions about her husband? She still is married, even though they're not in a traditional relationship. She still is married to Ruben legally.
I don't know how much the court will allow probing into communication between Susan Flores and her legal husband, Ruben Flores, even though technically they've been living, as I understand it, living apart for many years. They're still technically married, and they're still entitled to the marital communication privilege, which prevents the law from penetrating those communications. I think what the other part of what you were inquiring was whether she'd be allowed to testify at all, given the fact that she's sitting in the courtroom.
Yeah, exactly. Or how the judge determines who can sit in the courtroom ahead of testifying and who can't.
Well, it's completely discretionary with the judge or the court. Most of the time, the court will not allow any witness to sit in a courtroom, regardless of the relationship. However, I've noticed in my experience that judges, especially in the more serious cases, like the case against Mr. Flores, when there's so much writing on it, the court will allow a family member to sit in the courtroom and be there as support for the defendant because of the strong family relationship, being a mother or a father or a sibling or whatever. But I can assure you, if the defendant's mom, if her testimony was critical, if the court felt that the defendant's mom, her testimony was of such importance to the case, I don't care how close they are, mother and son, no judge would allow her to sit in the courtroom if her testimony was so important. I suspect it's not. I'm not saying it's not important, but not that important where the prosecution would be prejudiced if Mrs. Flores sat in the court.
What about the order of witnesses? How is that chosen? Obviously, you can't speak to the prosecution side, but when you are deciding what witnesses to call first, I'm kind of assuming maybe, and maybe I shouldn't be assuming, that the family members of Kristin Smart testified first so they can sit in the courtroom. Like each of them, was obviously barred from the courtroom until they testified, but now all of the family members have testified and they are sitting in court every day.
Right, that could be part of the orders, that the pretrial order that the judge made. I don't know. If the witness is excused after the witness completes his or her testimony, if the witness is excused by the court, then they're no longer a witness, and then they can sit in the court. A trick that attorneys like to do is when the court invites the attorneys. Do any of the attorneys have an objection to the witness being excused? One of the attorneys will pipe up and say, yes, I want the witness subject to recall.
Yeah, that's happened, honestly, with every single witness, minus the family.
Yes, yeah. And so in terms of the order, there's two theories here that apply: primacy and recency. So it's all about the impact of the testimony. So some lawyers feel that you want to present your most powerful evidence right in the beginning of the trial to hook the jury in to the testimony, to the witness, and to the strength of your case. Other juries believe you should build it up and until the end. In other words, recency, so the jury, when it goes into deliberations, will remember the more recent evidence and will place more weight on that than what they heard 3, 4, 5 months ago when the first witness was thought to be the all-powerful testimony that the attorneys felt was necessary to begin the case. I suspect, because of the length of this case, that both sides will focus on recency, because the cases will take such a long time that you want to save your best for last.
Let's before we run out of time here, let's get to this idea of cost. Obviously the Floreses have hired their own attorneys; they're not being represented by a public defender. I'm assuming, and all of our viewers kind of want to know, what kind of numbers are we talking about? How much does it cost? And where is that money coming from? The average person doesn't have that kind of money to sort of cough up in terms of paying for defense lawyers.
Well, I can tell you that my sense, based on everything that I know and my judgment, this is going to be in the neighborhood of $400,000 to $500,000 easy. My hourly rate is $500. I think Mrs. Sanger says that is in that neighborhood. We're talking about traveling to Monterey County, which is several hundred miles from Mr. Sanger's base. He has a private investigator that is there. He's had another attorney work with him. These issues this case is extremely complex, covers 25 years of material, thousands and thousands of pages to review, multiple witnesses that have to be contacted and examined and on call. So yeah, this would cost at least a house.
So it's funny that you bring that up. Is that one of the ways that the cost can be covered? And I asked this question because I looked into that, and and the house that was owned by Paul Flores was actually transferred into a trust, for instance, when he was right around the time of his arrest. And I might be reading into that. I just wanted to look and see if there was any connection there.
Fees can come in all shapes and sizes. God knows, I once took a rowboat with a couple of oars, and I've had I have taken a house one time. The key is to make sure the house is not encumbered.
Yeah.
But yeah, I mean, as long as there's full disclosures and as long as it's legal tender, I think a defense attorney will take almost anything that's clean.
I think some of our viewers too want to know, like, whether some defense attorneys might take cases like this just for the kind of notoriety of it, or for additional, like, the ability to get additional clients. Does that ever factor in?
I think absolutely. There are, you know, I remember my first trial, I took the case, this was, I don't know, 1980, maybe 1979 even. I took a case that included a 2-week trial for in the whole case for $1,000. And I just wanted it for the experience. My client couldn't believe that, you know, I mean, today $1,000 is 2 hours of my time. But I think I'm fortunate enough where I don't think I have to take a case for publicity, nor do I have to take a case just to make money. I'm not suggesting that's not significant. That's very significant. But if the client is a jerk, if I don't like the client, I'm grateful that at this point in my life I can tell the client to go find somewhere else.
And likely we will never know, right? This is not something that has to be disclosed.
What has
like the cost, or the, you know, nobody has to disclose it, right? Whatever deal was made between those attorneys and the Flores family is their deal.
It's all confidential.
Yeah.
It's part of the attorney-client communication privilege.
Yeah. So and likely, you know, we're gonna never find out.
Let me just add one thing.
Uh-huh.
If the money or the in-kind money is provided by a third party, there's no communication between that third party and the attorney. The attorney's entire fiduciary relationship, confidentiality, is owed exclusively to the client. So when you say it won't be exposed, I'm not suggesting. Let's assume that the parents, and it's not that unusual for parents to help their children when they're in trouble. Let's assume that the parents are helping Mr. Flores. You know, if they want to disclose it, there's nothing to prevent it. If I can virtually, I wouldn't be surprised if the prosecution probes that area to determine the bias. But that's a dangerous area, because if for example, if the family is supporting their son to the tune of $500,000, let's say, that's a sword that can cut both ways. You know, what would any parent do if a parent thought their son was innocent? If my mother were alive, she'd give me everything she has to support me. So, but there's no confidentiality protection with a third party between the third party and the attorney. So I just want to explain that.
Well, we very much thank you for your time, and we'll hopefully call on you again as we kind of work our way through this. We're just trying to put these shows together once a week so we can kind of give people a different perspective than what they're seeing on the nightly news every night. So we appreciate your time. Thank you so much for joining us.
Thank you. It was my pleasure.
All right.
Pleasure. Have a good day.
Thank you. And thank you for joining us as well for this special broadcast. And we want to say thanks again, obviously, to my guest, Ilan Funke-Bilu. We do plan to bring you these Facebook Live shows throughout the rest of the trial, so we do hope that you'll join us again next time. And remember to add any questions that you may have into the comment section. If we didn't cover your questions tonight, we will be compiling them for future episodes. You can also find all of our coverage of this case on our website, ksby.com. Thanks again, and we will see you next time.